So hi friends, today we'll start with GS-2 Polity. This quick recap, starting with the introduction to Constitution. According to the syllabus, so what is Constitution? Constitution is a famous dialogue is body of laws, but there are some laws which are outside the Constitution like RTA Act, Consumer Dispute Act, and Human Rights Act. Human Rights Act. These are outside the Constitution, so this is not a body of law. This is fundamental laws. Okay, this is the fundamental laws. This is impossible. This to make this as amend, change, remove. They are more difficult. There are some other laws that are done by Parliament, state legislature. These are all statutory laws. This is called fundamental laws. This is called statutory laws. For this, to amend, change, and remove, this is easy. But for this, it is difficult. The Union Parliament is a creation of Constitution and hence cannot legislate laws that violates principal laws of the Constitution. Hence, we deduce that the law mentioned in the Constitution is something like a supreme law. These laws mentioned in the Constitution. The legislature of the Parliament to make law cannot violate supreme law. Parliament cannot violate supreme law that deals with fundamentals of existence of society, and this supreme law is termed as Constitution. This supreme law is termed as Constitution. This Parliament has no right to do anything with this supreme law. This is termed as Constitution. That's the legislative of the Parliament to make laws cannot violate supreme law that deals with the fundamentals of the existence of the society, and this supreme law is termed as Constitution. So Constitution can be termed as fundamental law. Here we go to the definition. Is termed as supreme law, fundamental law, or fundamental set of principle according to which a politically organized society is to be governed. This is the proper definition of fundamental law. It's a fundamental law. Can be termed as fundamental law or fundamental set of principles according to which a politically organized society is to be governed. This is also termed as or described as is also described as the law of the laws because this is a supreme law. Many colonized countries around the world, after they gained independence from the colonizers, the first task that they got involved was to frame constitution according to which nation will be the yes. And if we'll see some difference between constitution and statutory laws. Constitution and statutory laws. Point number one, constitution is fundamental law. Due to this fundamental character or nature, it enjoys superior position. This can be seen in the procedure required to change the provision because it is more difficult to amend. Okay, the constitutional law, while being part of constitution, is part of fundamental, and hence it is more difficult to change, amend, remove. This is more difficult compared to the structural laws. Let's see the constitution laws. This is usually termed as entire body of laws because it is also known as law of laws. Is termed as central body of laws. Although there is nothing wrong with the definition, it is slightly a wider term because constitution laws goes beyond the mention of the constitution. Yes, because there are some constitution, there are some laws which are outside the constitution, and thus laws are being governed in accordance with the constitution. That's why this is usually termed as entire body of laws. It includes whatever there is there in the constitution, the subsequent amendments, interpretation of Supreme Court, in various cases before the court, and the convention that have evolved over time, even though convention was not been codified. For example, if you see the fact that the leader of majority is leader of the majority party is invited to formation of the government is not codified in the constitution, but it is still followed due to being a convention. The leader of the majority, leader of the majority of the party is invited to form government, even though this is not mentioned in the constitution, it is being convention. In the case of governor, Sarkari Commission, Sarkari Commission suggestion appointing a person from another state than the state is being appointed to. This is convention, but it's usually followed. It says, in case of governor, the Sarkari Commission suggestion appointing a person from another state than the state is being appointed. Okay? Now, because it means the state, for example, if the governor belongs to Telangana state, he should not be appointed to Telangana, he should be appointed to Samajliga and any other states apart from Telangana. This is the convention. Okay, and next, if you see significance of constitution. So till now, what we have seen is the definition. What is constitution? The definition. And we have seen the difference between the constitutional laws and statutory laws. And now we will see the significance of the constitution. The first act after the birth of the nation is framing a constitution. Post independence, the first act it sets up some common set of norms or common normative home to which diverse elements of society interact harmoniously with each other. Means it is kind of uh, a guided book which sets some norms, common normative home through which caste diverse caste, like caste, religion, discrimination, uh, gender, society, and so on. These diverse elements of society interact harmoniously with each other. It's also called the birth certificate to the nation, what constitution. It gives basic structure of our polity or system of governance. If we make notes like this, this is also called birth certificate of nation, and it is also called basic structure of our polity or system of governance. It also details the patterns of relation between details the relationship between legislative, executive, judiciary, and it sets up some norms where diverse element diverse elements interact harmoniously with each other. It also details the relation between relation between state and constituent citizens. Okay. It also details the ideals and aspirations of people as visible throughout the Constitution, particularly in the preamble. Ideals and aspirations of the people throughout the Constitution through preamble, particularly in the preamble. Ideals and aspirations of the people uh, through throughout the Constitution, particularly in the preamble. It also acts as minor to the society and it highlights faults within our society and tries to address them. It also acts as mirror to the society and it highlights faults within our society and tries to address them for if their faults were not addressed and they will be tormented. The Constitution gives legitimacy, legitimacy to the states. And democratic government cannot be absolute. Yes, government cannot be absolute because uh, one person cannot hold all the thing, all the powers. Absolute, absolute, absolutist, and hence the legal enforceable limitations on the government to prevent absolutism. If there are legally enforceable limitations to prevent absolutism, the constitution is the only place where legally enforceable limitations can be placed on state authority. This saying about in a democratic nation. India is a democratic country, and in a democratic nation, the government cannot be absolutist. Hence, there are legally enforceable laws or legally enforceable limitations are there to prevent absolutism. And these limitations are placed in the constitution. Okay, these are the significance. If we go with declaration, it is also called as birth certificate of the nation, and it has some basic structure of our polity and system of governance, and shows the relationship between the legislative, executive, and judiciary, and it sets up basic some norms where it sets up some norms where diverse elements interact with each other harmoniously, and shows the relationship between state and conscious citizens, and it shows the ideals and aspirations of the people visible throughout the constitution, particularly in the preamble, and it prevents the government to be absolutist. And constitution has the laws which give limitation to prevent absolutism. Oh no, what is constitution? Constitution. it is a complex set of ideas that is based on the principle that the power it is complex. So it is a set of ideas. Constitution is a set of ideas. Is it easy? No, it is a complex set of ideas that is based on the principle. So it is this is some set of ideas based on some principle that power of the government are not absolute and are limited to the body of laws or a supreme law called constitution. What does the principle power of the government are not absolute and are limited by a body of laws or supreme law called constitution. So this is the principle. Let's revise this definition again. What's the constitution? Constitution is a complex set of principles. It is complex. It's a set of ideas based on the principle where power of the government, where the power of the government is not absolute. The power of the government is not absolute and are limited by a body of laws or a supreme law called constitution. The power of the government is not absolute. It is limited by a body of laws or a supreme law called a constitution. What are this principle? What are this body of law? What are these laws? Point number one, you see components of this principle, rule of law. Although many people have contributed to the principle of rule of law principle in Taisi constitution has been more similar. Rule of law has many components, but basically it means rule by law. Rule of law is basically it means rule by law. It has components. It has many components, namely supremacy of the law. Supremacy of the law means the country will be ruled not according to the whims and fancies of the ruler, but in terms of the principles of law, and the ruler is subjected to the law. Yes. The Supreme Court has also said that you may ever be so high, but the law is above you. The law is the king of the kings. Even the Upanishad express similar sentiments when we mention the dharma of the king. Lex is rex. The law is king of the kings, which means it is saying that in terms of the principles of law, the ruler is subjected to the law. Whoever the government or the anyone who the ruler is subjected to the law. Supreme Court said that you may ever be so high, you may ever be so high, but the law is above you. The law is above you, and the law is king of the king. The naturally corollary of this postulate will be thus the arbitrary exercise of public prohibited equal to the law. Rule by law, equality before law. What this is, Dyson said that all the sections of society are equally subject to the law. All the sections are equally subject to the law, equally subjected to the law of the land as administered throughout the ordinary courts. Throughout ordinary, all the sections of society are equally subject to the law, equally subject to the law as administered through the ordinary courts. Though in modern practice, steps related to affirmative actions or positive discrimination violate the strict application of this principle, but are in tune with modern times. Then it is extremely more or less understood that all the sections of the society are equally subject to the law of land and administered through the ordinary courts. So the main practice steps related to the affirmative actions of the positive discrimination violates the strict applications of the principle, but in tune with modern times. The second thing, the difference between the first one, rule of law. Rule of law is also called as rule by law, component, supremacy of law. Second one, equality of law. Supremacy of law, it says law is the king of the kings, equality of law. All the sections of society are equal before the law. Equality was law administered through ordinary laws. But today we have many forums that have adjudicatory functions other than ordinary courts as said by IC. As example is constitutional form like CAT, ITAT, tribunals. So other than courts, ordinary courts like Supreme Court, High Court, other than we have another um, adjudicatory, adjudicatory functions will perform with the tribunals, where with the equal judgments, and CAT, ITAT. There are certain exceptions to legal equality in the constitution while president and governor in office. In Indian constitution, there are certain exceptions to president and governor. These are mentioned in the Indian constitution. Okay, no criminal proceeding can be stated against them as per Article 360. 361. No criminal proceedings can be stated against president or government. And no civil decisions can be undertaken unless 2 months notice. No civil, no civil disputes can be undertaken unless 2 months notice. These are certain exceptions which are given to the president and government and which is mentioned in the Indian Constitution. No criminal proceedings and Article 361 and no civil dispute can be undertaken unless 2 months notice. Okay. 18 Nonani termed this criminal exception to be mindless plotting for lovers based on British practice that courts cannot prosecute a murder. In Britain, the courts are certain courts are the in Britain, the courts are the creation of grounds and hence prosecute. Okay. This is about the introduction to the constitution. First, we have seen the definition. Yes. And second, we have seen the difference between constitutional laws and statutory laws. And then we have seen the significant, and then we have seen the constitutionalism, the components rule of law, rule by law, supremacy of the law, equality before law, and equality. So if you see equality before law, the subject of land, basically all the sections of the equal subject to the land of the as administered through ordinary courts. Other than ordinary courts. Okay, we will discuss about the separation of powers.